167, sir.
In the state of Texas versus,
Frederick Maurice Byrd.
say again, slowly.
Frederick Maurice Byrd, spelled B-Y-R-D.
And the first name again?
Frederick.
Frederick.
F-R-E-D-R-I-C-K.
All right. This is a motion brought by defense on the issue of speedy trial. Is that correct, Ms. Gonzalez?
Yes, Your Honor, that is correct.
All right.
And just for clarification for the court, there was a original motion for speedy trial that was filed and accepted by the clerk's office on accepted on February 10th, 2020. It was originally titled Motion for Speedy Trial with arguments that were laid out. However, I went ahead and filed on, and it was accepted on June 29th, a motion to dismiss for lack of due diligence and violation of right to speedy trial. And that is actually the motion that is before the court today.
Motion to dismiss.
For lack of due diligence and violation of right to speedy trial.
All right. Patty, give me the date of the offense.
Well, Your Honor, if you prefer, I was going to go ahead and ask the court to take judicial notice of several dates that should be contained in the file, if I can just go ahead and recite everything.
Okay, let's cover one thing first.
Okay.
First of all, this is a hearing held remotely because of the COVID-19 pandemic. This is also being live streamed through YouTube. Is that correct, Ms. Garcia?
That's correct, Judge.
All right. And for the record, the defendant, Mr. Byrd.
Yes, sir.
Would you, just for the record at this point, would you raise your right hand? You solemnly swear that in this proceeding, any information, testimony, or responses that you give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
All right, you may put your hand down. Mr. Byrd, I inform you and remind you that this is a matter involving charges against you for alleged criminal activity, and you at all times have a right to remain silent. I don't have any doubt that your attorney has spoken to you about that, but I want to make sure that you know and understand that you have that right. You do not have to answer any questions. You do not have to make any statements. You do not have, if you do, you do not have to submit any kind of written documents that have your signature in this proceeding, albeit this is a pretrial proceeding and not an actual trial with or without jury. Do you understand that?
Yes, sir.
All right. And if your attorney calls you, I will ask you at that time if you understand that you don't have to give testimony. I don't know. I expect that she will call you just right, but I don't know that for a fact.
Yes, sir.
Now, since this involves a criminal allegation, you have a right to be in open court. You understand that?
Yes, sir.
And because of the exigence, we've set it up remotely through the computers, and you are in agreement and waive the right to have this proceeding in an open court. Is that correct?
Yes, sir.
Now, I will repeat, this is a public proceeding because we're doing this through technology, through YouTube. You understand that?
Yes, sir.
And you are waiving the right to have this in open court.
Yes, sir.
Thank you. Now, Ms. Gonzalez, you are
Yes.
ready?
Yes, Your Honor, I am ready.
Mr. Edelman, you're ready?
Ready, sir.
All right, Ms. Gonzalez, it's your motion.
Thank you, Your Honor. So before we get into the actual testimony, I would like the court to take judicial notice of several dates that should be contained in the court's file. The offense is alleged to have been committed on November 16, 2017. That is the date that he was arrested and he was magistrated by Bexar County, and a bond was set in the amount of $1,600. He was released from jail on November 17, 2017. The next date that I would like to highlight before the court is that on December 1st, 2017, an affidavit of surety was filed by which I'm assuming is going to be the bonding agency. On December 4th, 2017, a warrant was issued in this case. It looks
Fourth, you
like,
said?
I'm sorry, December 4th, 2017.
What was it that was done? I'm sorry.
There was a warrant that was issued for my client, and there was a bond set by Judge Johnson in the amount of $3,200. The next date is on, well, there's a lot of dates on here, but the next date I want to highlight to the court is that on December 12th, 2017, it shows that the client had an arraignment that was set. He was awaiting docket appearance, and that there is a failure to appear that is entered on that date. After that, the next entries by the clerks are going to come in October 21st of 2019. That is where it shows in the system that the warrant was executed. It was returned back to the court. There was a defense attorney that was appointed on that date. My client was magistrated. And then this is where there's a little bit of confusion and I don't know what's going on, but it looks like there's an entry on November 26, 2019 for an arraignment setting. And then there's on December 20th, 2019, there's entries awaiting hearing, pretrial conference, and then that is where there's an entry notation of me, Jessica Gonzalez, being appointed onto this onto this case. The next court setting is going to be on February 7th, awaiting hearing. I believe on that date is when I, as the attorney, set it onto the trial docket for the first trial setting on April 1st, 2020. And also on that date, that is where I recited over to the court that I filed the first speedy trial motion on that date, and it was accepted on February 10th.
Okay.
So the first thing I would like to do is to call the first witness I have. Our first witness, let me get to that name, is going to be Tyneek Bird.
Yes.
Your Honor, she needs to be sworn in.
Where is she?
Well, there's a screen share going on. I don't know if we still need to do the screen share, but I have her on the right side of my screen since there's the screen share with the motion up, and she should be on there. I can only see the top of her hair. If she moves the phone down a little bit, she should be in face view, but she is on the screen. Tony, can you say your name?
The last name is Bird. What's the first name?
Tyneek, and I can have her spell it once she's been sworn in to
I
testify.
appreciate it. Can you spell that slowly, ma'am?
Tyraneque.
TYIA.
RA.
TUE.
Yes.
And how in the world do you say that?
Tyraneque.
Okay, I'll take your word for it. There's no way I'm gonna get it straight. All right. Would you, Ms. Bird, would you please raise your right hand? The other right, that one, there you go. Do you solemnly swear that in this proceeding, any testimony or responses you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. You may put your hand down. Okay, and try to stay close to the microphone on the device, okay? Can you hear me clearly?
All right, thank you, Tyronique. Can you please state your full name for the record again?
Tyronique Drayshawn Bird,
All right, and what is your date of birth?
December 3rd, 2002.
So as of right now, you are 17 years old, correct?
Yes.
Were you how are you related to Frederick?
He's my cousin.
All right, and were you with your cousin Frederick on the day that he was arrested in 2017?
Yes.
Where were you guys?
We were in the car, like right by the house, like
Okay.
right in the corner.
And how many people were in the vehicle, if you remember?
It was me, him, my friends, Humana and Gloria, and I think his ex-girlfriend.
Ex-girlfriend or possibly another cousin?
Ex-girlfriend.
Okay. And so you were there when he was arrested, correct?
Yes.
Okay. And what do you remember from that arrest?
Objection, Your Honor, outside the scope.
Us getting pulled over for the
Hold on.
Hold on, ma'am.
Your Honor, may I respond?
Hold on. If either witness, Ms. Bird, if either attorney says objection, then you have to stop testifying and wait until I ruled, okay? All right, Ms. Gonzalez.
Yes, Your Honor. Whether or not the witness actually remembers the events of the arrest actually goes to the point of a speedy trial motion and is one of the elements that from the Barker-Wingo factors I would have to show as far as whether or not my client has been prejudiced by any violation.
All right, I will overrule the objection, but I want you to limit this topic, okay?
Understood, Your Honor. All right, Tyronique, you can go ahead and answer the question. Do you remember what happened on the day of the arrest?
I don't remember any conversations. I just remember us getting pulled over for the the air freshener that was in the car.
Okay, but you do not remember the conversation between your cousin Trey and the police officer?
No.
Okay. And you said there was you have two friends that were in the car?
Mm-hmm.
Has Trey asked you, I'm sorry, has Frederick asked you
Ms.
to
Gonzalez,
look?
hold on. The response was,
Oh, I'm sorry. We need a verbal response of yes and no.
Yes.
Okay.
Thank
And when you spoke with Frederick, did he ask you to try to get in touch with your two friends?
Objection, hearsay.
Yes.
Hold on, we need a ruling. And Your Honor, may I respond?
wait up.
First of all, it is not for the truth of the matter asserted as to whether or not what Frederick asked her to do. The information that we need to get to the court is what she actually did. So it's what she acted upon and why she did it. Second of all, my client is prepared to testify as to what he was asking. And actually, if we do not get this information into court when my client testifies, that will actually be hearsay. So I need to have Ms. Tyronique's information first.
Under that limited explanation, I'll overrule the objection.
Thank you, Your Honor. So were you able to get in touch with your two friends that were in the car?
No.
Thank you. I'll pass the witness.
You may proceed, Mr. Edelman.
Ms. Bird, what efforts
Yes.
did you expend to try to contact the other two people who were in the car on November 16th, 2017?
Excuse me?
What efforts did you expend? What did you
I just
do?
tried to text them, but they don't reply.
I see. Did you try to find them by any other manner or method?
No.
Nothing further.
Ms. Gonzalez.
I don't have any questions further for this witness.
Thank you, ma'am. We appreciate your testimony today and making yourself available. If you are, where are you at, Ms. Bird?
I'm at home.
Okay, does anyone have any problem excusing her for the rest of the hearing? Ms.
Your
Bird?
Honor, I do not expect any further need for her testimony. I think she's already laid out everything that I needed from her. So I'm okay with her being excused.
Okay,
Well, Your Honor, I would like her subject to recall. I don't know exactly what Mr. Byrd is going to say. And so
All right.
in case I need to cross-examine Ms. Byrd further in relation to what Mr. Byrd tells the court, I would like
All
to
right.
have that option.
that is fine. Then, Ms. Bird, just stick around. Don't leave. Stay on your is it phone? You're on the iPhone?
Yes.
Hold on, wait, my phone is about to die.
I'm sorry.
He's trying to get over to a battery charger, Your Honor. I would just ask if Ms. Byrd is going to need to stay on just to be able to help for Kayleen for the record, if she can put herself on mute, or if the host can put her on mute. So that way there's no sound problems from her for the record.
All right, very good. It'll so ordered. All right,
Okay.
Ms. Gonzalez, what else?
Yes, Your Honor. My next witness is going to be Trey. I'm sorry, it says Trey on my screen, but it's going to be my client, Frederick Byrd.
Yes, ma'am.
And Your Honor, he's already been previously sworn. So can I go ahead and start?
I'm sorry, I'm having a little bit of trouble hearing y'all.
He has been previously sworn in by this court.
All right, you may proceed.
Thank you, Your Honor. And just for the record, I'm also calling my client, Frederick, for the limited purposes of testifying in this hearing.
It's so noted.
Thank you. May I proceed?
Yes, you may.
Thank you. Frederick, can you please state your name for the record?
Frederick Mauricio Traquan Deontay Byrd.
Thank you. And are you the person who was arrested and charged with the offense of terroristic threat on a public servant?
Yes, ma'am.
And do you remember the day that you were arrested?
Yes, but not like really.
Okay. Is it because it's been for a very long time?
Yes, ma'am.
All right. So it wasn't back in 2017 that you were arrested, correct?
Yeah.
I'm sorry, can you repeat the answer?
Can you repeat the question?
Yes, it was back in 2017 that you were arrested, correct?
Yes, ma'am.
Objection, leading.
Your
What
Honor,
was
there was an objection to leading.
Oh, I'll overrule that.
Thank you, Your Honor. Now, when you were arrested in 2017, did you post bond?
Yes, ma'am.
And do you remember getting any paperwork as far as the court date? We seem to have technical difficulty, Your Honor. Hold on a minute. Trey, are you still there? Or Frederick? Your Honor, can I have a moment to call my client?
Of course. Looks like Kayleen is about to fall out of her chair since she's sitting sideways, and we've lost Trey. There you go. Now you're safe. Okay, man.
Your Honor, it went straight to voicemail, so I'm going to assume that the battery did end up dying. So I'm going to give it a few minutes and see if you can find a charger.
Already. I will repeat my often repeated phrase. To err is human, to forgive divine, but to really screw up, what do we need? A computer.
There we
Hey,
go.
there he is. Are you back with us? Can you hear us, Mr. Bird?
Yes, can y'all hear me?
Yes. Okay. Frederick, you
Sorry,
got
my
a different
phone had
phone.
died.
Okay.
Yeah, my phone had died.
Okay. All right. May I continue, Your Honor?
Yes, ma'am.
All right. Frederick, from back when you were arrested in November of 2017, do you remember if you received any paperwork as far as your court date?
I did not.
And were you aware that you actually had a court date in December of 2017?
No, I was not aware.
What did you believe happened to the charge that you were arrested for?
I thought it was dismissed or got dropped. To be honest, I don't know. When I got let go, I didn't receive no paper saying I had to go to court. I know none of that. So I was thinking like, well, maybe it got dropped or dismissed. So I've just been living my life thinking I was warrant free or just free.
All right. So when was the first time that you found out that there was a warrant for your arrest?
I was at work and a lady accused me of stealing like $10 from her, which was absurd. And the officer was going to let me go, but then he ran my name and said I had a warrant from 2017. And I was like, I was so in shock. I almost cried because I was like, I didn't even remember this happening.
All right. So, and what was the date, if you remember, that you found out about the warrant?
It was, I believe, sometime in December when I had went to jail.
Okay.
I can't give you an exact date.
All right. Let's start with what year. Do you remember what year?
Yes, it was 2019.
All right. And you said you believe it was in the fall or winter of 2019?
Yes, ma'am.
Now, once you did find out about this warrant, at that time, did you receive court information?
You said, can you repeat that?
At that time, when you got booked in 2019, did you receive the information about the court date?
About like going to court this time?
Yes.
Yeah.
Did you go to court in December of 2019?
Yes. For this case, yes.
Okay. And in between the time that you got arrested for the terroristic threat the first time in 2017, and then when you got arrested for the warrant in 2019, have you been stopped for any traffic violations?
Yes, I've been stopped for driving without a license, speeding in a school zone, driving without a seatbelt. I have a couple tickets.
Okay. So when you having a couple tickets, any of those officers, when they stopped you, did they tell you you had a warrant?
No, ma'am.
All right. Furthermore, do you have an identification card from the state of Texas?
I lost it. I had one, but I lost it. I'm trying to get one like right now.
All right. And when was the last time you had your identification card renewed?
It was literally like 2-3 months before I had got arrested.
Okay. So theoretically, while the warrant was active, you went into the department and renewed an identification card.
Yes, ma'am, because they told me I was gonna have to renew my ID on my birthday anyway, so I was like, why not do it right then?
And then from when you were arrested, from what you remember on that day that you were arrested for the offensive terroristic threat on a public servant, who was in the vehicle with you?
It was me, my little cousin Tyranique, her 2 friends, and my little cousin Kiana.
Okay. So with regard to Kiana, what is Kiana's name?
Her name is Kiana Alicia. Her last name was Bird, but she got adopted to my auntie them, so I believe her last name is Phillips now.
All right. And does she live in San Antonio right now?
No, she's in Oklahoma.
When did she move to Oklahoma?
I say like, what, 3-4 months ago?
And with her being in Oklahoma, can you afford the travel expenses for her to return back to San Antonio for trial?
No, man, I tried my hardest. I can't.
Now, with that being said, would she be a witness that you would need in order to prepare for your defense and present a defense in a jury trial?
Yes.
And you stated that when you were working when you were arrested at the hotel in 2019?
Yes, ma'am.
And what were you working as?
I was working as a PCT, a patient care technician, under ResaCare is, I believe it's EduCare. I had that job for, I want to say, what, 6-7 months?
Okay, and that is a agency that is followed by the state of Texas for healthcare of individuals, correct?
Yes, ma'am.
Now, when they did arrest you that day, were you aware that there was that warrant outstanding for the terroristic threat?
No, ma'am. I did not know anything about it. I thought I was going home until he told me I had a warrant.
Had you known that there was a warrant, would you have tried to resolve the matter appropriately?
Yes, ma'am.
The day that you met with me for the first, our first docket appearance, that was in February of 2020. Did we review the facts of the case?
Yes, ma'am.
Did I explain to you what the officer was saying happened on that day?
Yes, ma'am.
And did you tell me that you believed that that was incorrect and you wanted a jury trial?
Yes, ma'am.
And on that day, did I set this case for a jury trial?
Yes, ma'am.
Thank you, Your Honor. I'll pass the witness.
Thank you, ma'am. Mr. Edelman.
Mr. Byrd,
Yes,
Would
sir.
you-
How you doing?
relatively well, thank you. Would you repeat your full name for the record, please?
Frederick Mauricio Traquan Deontay Bird.
And is that entire name on your identification card?
Yes, sir.
Interesting. Now, I'd like to show you something. Can you see that?
Yes, sir.
Do you see where it says defendant's signature?
Yes, sir.
Is that your signature?
Yes, sir.
And what does this document that you signed say?
At law number 5 at the Barry County Justice Center, 4th floor. Okay, is basically saying that I signed, saying that I got a court date.
It's not just saying that you have a court date. It's saying that no other notice will be given. It says that failure to appear will result in a warrant for your arrest. And it also says that you received a copy of this order and you signed it, did you not?
Yes, this is what I'm seeing.
So according to this document,
Objection, Your Honor. Can the prosecutor scroll up so I can see the part that he's saying that he received a copy of this? I don't see that on my screen.
Right above his signature, Ms. Gonzalez.
I understand that. Oh, okay. I see it. Thank you.
so you signed this order, which stated that you received a copy of it.
Yes, that's what it's looking like. I promise you, I don't remember signing this.
So you don't remember signing it,
No, sir.
and you don't
But that
remember
is my
receiving it.
But that is my signature. And I don't remember receiving it in the mail. No.
But you not receiving it and you not remembering signing it is very different from you actually not receiving it and you actually not signing it, isn't it?
Okay, but I got a question because that signature, I couldn't have sent it. I mean, signed it, then sent it back. That would have to be when they released me. And I didn't get no papers in the mail recording my court date or warrant out for my arrest. And that is my signature. I'm not saying that it isn't my signature. That is my signature, but I really do not remember signing this.
Next. Do you recognize this?
Nope.
Where it says signed and dated, is that your signature?
Nope, it is not.
So where it says signed and dated,
Oh no,
that's
yes,
not
that
your
is.
signature.
Yes, that is mine.
So that's your signature.
Yes.
And on what date was it signed?
11/17/17.
And that's your thumbprint of your right index finger?
Yes, sir.
And this gave you the instructions of what you needed to do and where you needed to go, does it not?
Where before CC5. Yes, sir.
And it gave you the address and phone number of your bond company, does it not?
Yes, but I can't really see the address.
And Your Honor, again, can the prosecutor scroll down to the full document? Your Honor, I'm going to object to one of the line of questioning of this prosecutor. It does provide the charge and the court. However, from what I read, there was no date of a court date that was on this document. You can scroll back up.
Well, Your Honor, I didn't ask if it had the date of his court date, but only the date on which he signed it.
I'll overrule the objection. It is appropriate cross.
So
Any
you
conclusions to be
signed.
made concerning dates, we'll have to look at the document. Can you scroll it back up, Mr. Edelman?
Yes, sir.
Does it show a specific date on there?
It shows, from what I can see, Your Honor, it shows the date that it was actually signed. However, it does not have a court date on this document. It just says that
Can you
he's
scroll up a little
charged.
further? Okay, what does it show there?
That's November
Alright, November
17th,
2nd.
November 28, 2017. And it's blocked out for the court setting, whatever that stamp is. It has the cause number and the charge. But on this document, I just want to make sure that the record's clear that the document does not have the court date on there. And I believe that was the question one of the questions that was asked by the prosecutor.
And I'm going to go back to the previous document. Your court date was for December 12th, 2017, was it not, according to this?
Yes, sir. According to that.
And do you see this 12/12 in the corner?
Yes, I see it now.
Thank you. So, Mr. Byrd, you variously signed documents that told you where you needed to go, when you needed to go there, the physical address of the room where you needed to go, the results of what would happen if you didn't go there, and that you had received copies of the order giving you all of that information, and that you had signed a document telling you who your bondsman was, where they were located, and their telephone number. You signed all of those, didn't you?
Yes, sir.
I see. So you said you've had a couple of tickets over the years.
Yes, sir.
What dates did you get them?
I can't give you dates of every single last ticket I got. I can't really tell you. I just know that if you were to, I believe, when a matter of fact, when I went to jail, I talked to the judge in the magistrate about my tickets, and then that's when they shipped me over to Bear County. He said I would have to take care of my tickets, or I would be back in there. But I haven't been up there to pay my tickets because I ain't had the money yet. But yes, sir, I have had tickets.
Okay, do you have any documentation of the tickets that you received at various times?
No, sir.
Do you know in what jurisdictions you received them for?
San Antonio, Bear County.
Well, which is it, San Antonio or Bear County? Because they're different jurisdictions.
Is some in Bear County and some in San Antonio. I know there's two different sections. That's why I said some in Bear County, San Antonio.
So you used your full and complete name and your full and complete date of birth on all of them,
Yes.
but you can't remember what dates they were issued to you. You haven't provided any of the citations, so we can't see what information the officers actually wrote down based on what you told them.
So that was a question?
Yes, it was a question.
Okay, I don't believe anybody is just going to remember the dates of their tickets. You have to have an outstanding memory for that. So yeah, and then like I don't know what to say. I mean, I can't tell you the exact time and dates and street that I got stopped on. I can tell you one street was on Bandera. I mean, that's about it. But other than that, I wasn't too much worried about those tickets. I had so much other things to worry about. I can't tell you the date or the time.
So you had your cousin, let me make sure that I'm saying this name correctly, Tyrannique in the vehicle.
Tyranny. Yes, sir.
And then there were 3 other people, if I understood your testimony correct?
Yes, her 2 friends, Gloria and Jimena, and my little cousin, Kiana.
And it's only Kiana that you testified has moved to Oklahoma and is incapable of returning because of a lack of resources?
Yes, sir.
Did you ask your attorney to ask the court to secure resources for her transfer?
I didn't know that was possible.
Did you ask your attorney to request a deposition to secure her testimony because she would be unable to travel?
Your
Once
Honor,
again-
objection, that suggestion violates the rules of evidence.
Your Honor, if I may respond.
I'm gonna overrule the objection. It's still within the bounds of cross.
So, Mr. Bird, would you like me to repeat the question so that you may answer it?
Yes, sir.
Did you ask your attorney to ask the court to order a deposition for Ms. Phillips to be able to secure her testimony despite her inability to travel?
No, sir. I did not know anything about that.
And have you asked Tyrannique to ask her 2 friends if they would appear in court to testify?
Yes,
Or
I
make
did
themselves
ask her.
available? And after she gave you a negative response that they would not answer, did you direct your attorney to ask the court to release resources to investigate their whereabouts?
No, I did not. And can I say something?
Please do.
Okay. Your line of questioning just kind of like threw me all the way off, and I felt some type of way because I feel like you was talking to me as if I'm a criminal, and only criminals should know that, because me personally, I don't get in trouble to where I know that my lawyer can do such things as you just said. So I'm not gonna lie to you, I just kind of felt offended because how was I just supposed to know that? And That's not right. I didn't know that. Only criminals know that. My uncle didn't know that. I'm not no criminal. I feel this is the first time in my lifetime that if you looked at my record, sir, you should see that I have nothing on my record. So for you to ask me those questions, I kind of felt kind of felt hurt. And yeah, I didn't like that line of questioning just now.
No
That's it.
further questions. No further questions for Mr. Byrd, Your Honor.
Ms. Gonzalez, anything else?
One moment, Your Honor. Let me consult my notes. Nothing further from Mr. Byrd, Your Honor.
Thank you. Mr. Byrd, you can relax. Ms. Gonzalez, your next witness.
Your Honor, defense has no additional witnesses.
All right. Mr. Edelman, do you have any witnesses?
No, Your Honor.
All right. Argument, Ms. Gonzalez.
Yes, Your Honor. The first thing I would like to point out, well, Your Honor, as we've done the speedy trial motions before, the court is well aware of the fact that there are four factors that are taken into consideration as to whether or not my client's rights for speedy trial have been violated. From Barker Wingo, the first thing that we're going to look at is going to be the length of the delay. What we're talking about here right now is a 2.5-year delay. At the 8-month triggering point, there is already a presumption of prejudice that is going to shift to the district attorney's office to dispute the fact that there is no prejudice. The second thing that the court needs to look at is going to be the reason for the delay. While there are things that are considered neutral reasons, as for the fact of a crowded docket, things like that, those are considered neutral. The state of Texas in this motion has not provided any reasons as to whether or not they did not execute the warrant. Your Honor, there is information contained within the district attorney's office. There's witnesses that they could have called to be able to explain why there was a warrant that was pending for over 22 months before it was actually executed. The last thing that the court needs to look at is going to be for the assertion of the rights, followed by the prejudice that my client has suffered because of this delay. When we're talking about the prejudice, even though the prejudice has been presumptively shown by the fact that there's been more than 8 months that have passed before since he was arrested, my client, Frederick, and his cousin have testified that there are not only memory problems with this case, but there's actually actual lost witnesses, one of which being in Oklahoma that cannot afford the travel expenses to be able to come back. In this particular case, we're talking about terroristic threat of a public servant. This is basically going to be a he said versus she said type of case. Whether or not my client, in order to be able to prepare a proper defense in this case, is going to need to have access to every single witness that is available for this case to be able to have them accurately testify to what happened on that day between the interaction of the officer and my client. And given the fact that this case has gone on for over 2.5 months, we already know that a witness has been gone for the travel that cannot afford to be able to come back, which is going to be an additional burden to my client. There's also a witness that has testified that she does not remember everything that happened during the actual police encounter. That is an actual and real prejudice that my client will face, and he will be hindered in being able to mount the proper defense to these charges. Now, the thing that I would like to note for the court is that the district attorney's office has not provided any evidence to the court to justify the fact that a warrant was not executed for over 22 months. While they have shown to the court that my client may have signed documents that he received a copy of the court date, there is no actual witness that has come in to testify that they actually gave him the documents. Furthermore, my client testified before the court that he does not remember receiving the documents. And that is a very different distinguishing fact that was pointed out by Mr. Eidelman. However, there's been no evidence that was offered to the court that shows that my client did receive the information. Furthermore, as was notated during the judicial notice that the court took of the court dates, the warrant actually issued before the court date. It was issued on December 4th. From December 4th, that warrant was never executed by the district attorney's office in order to pick him up and bring him forth to trial. My client does not have an obligation to present himself to the court for trial, and whether he does have the obligation to assert his right to a trial. However, it is the state's duty and responsibility in order to do everything diligently. And under Gonzalez v. State, Southwest 435 Southwest 3D 801. That is a Texas Court of Criminal Appeal case that actually originated from Bexar County, Texas, back in early 2014. That actually states that whether or not the district attorney's office actually met their obligations of bringing a person into the court to be able to answer the charges. Now, in that particular case, the appellant, Lionel Gonzalez, he was actually on probation for an unrelated offense. So even though he was on probation, the Court of Criminal Appeals stated the fact that he did not update his Texas driver's license with the correct address, that it was expired, and the fact that he was not reporting to probation. Even with those faults of the defendant, the state still has a duty to be able to explain the problems that they had with executing the warrant. They need to be able to justify this reason for the delay. In this particular case is going to be a 22-month delay, and they need to show evidence to the court that they're exercising diligence. Now, if you go and look back at the Code of Criminal Procedure, which I know the court is aware of, even this due diligence requirement is not something that's just manifested here for speedy trial issues. This due diligence requirement is actually already imposed by the state of Texas, even after a defendant takes punishment, deferred adjudication, or probation. They have the already obligations of reporting to the court. However, when the state of Texas files a motion to revoke the supervision, one of the requirements that the district attorney's office and probation have to show is that before that motion to revoke was entered, they used due diligence in bringing the defendant into court. Our argument to the court today is that if this due diligence requirement is required after a person has already gone through the court system, it should also be required when before a person has actually been convicted of a crime. And that falls under the Sixth Amendment right to a speedy trial. So for the fact that the state has not been able to provide any evidence to the court that my client has suffered an actual prejudice because of this delay, this is unjustifiable in their actions. They did not exercise due diligence in executing the warrant. And for those reasons, Your Honor, we are asking that this court find that the state of Texas failed in their requirements of due diligence, that my client's right to a speedy trial has been violated, and this case be dismissed.
Mr. Edelman.
Your Honor, before I proceed to my remarks, I'd like to ask defense counsel to repeat the citation for the case that she cited.
Yes, Your Honor. Give me one moment to pull up that document. It's going to be Gonzalez with an S.
435 Southwest 3rd, 801.
That is correct. And that case actually originated out of the 379th under Judge Ron Hell.
And Your Honor, since that case was not cited in the first paragraph of the defense's motion, will you give me a few minutes to read it to see if it has any distinguishing facts?
I have no problem with that. Go ahead.
Thank you, Your Honor.
Time's up.
It's very amusing, sir.
Go ahead. Do what you got to do. We'll wait.
While he's reading that, can I go use the restroom?
Your Honor, will you give Mr. Byrd permission to use the facilities while I'm reading this case?
Of course.
Thank you, sir.
I was gonna say, if he can put himself on mute. Please. I've watched the body worn camera videos where people do not put themselves on mute.
Oh, Lordy.
Judge,
Ma'am,
are you gonna excuse the witness now?
Mr. Edelman, you no longer need the lady, do you? Ms. Byrd?
That is correct, Your Honor.
All right. Thank you, Patty. Ms. Byrd, young lady?
Yes.
Okay, now you're excused. Now you can turn off your phone and do whatever you want to do the rest of the day.
Okay, thank you.
Thank you again for coming in or testifying.
You're welcome.
I am back.
Thank you. Well, y'all finish that. I'm gonna take a quick 5-minute break myself. Just hang in there. All right, Mr. Edelman, you ready?
Yes, sir. I believe I am.
All right. You may proceed with your part of the argument.
So I would like to begin by pointing out to defense counsel that my last name is pronounced Edelman.
I apologize, I always forget.
It's okay. The next thing that I'd like to bring to the court's attention is that Ms. Gonzalez's characterization of Barker v. Wingo is not entirely accurate. Once a court has found that a presumptive delay has occurred, the burden does not then shift to the state to rebut the presumption of innocence. Rather, the court then begins an analysis of the Barker v. Wingo factors. All of the factors are interrelated with one another, and no single factor by itself is controlling. Because the court must apply the Parker balancing test with common sense and sensitivity to ensure that charges are dismissed only when the evidence shows that a defendant's actual and asserted interest in a speedy trial has been infringed. Therefore, the state may be required to rebut some factors under given circumstances. The defense may be required to rebut some factors under some circumstances, and regardless, the court is required to engage in a balancing test between all of the factors to make a determination whether the defendant's right to a speedy trial was actually violated, requiring dismissal. Now, to go back to the Gonzalez case, the first distinguishing factor that really stands out to me is that in Gonzalez, the defendant was initially indicted and an arrest warrant was issued along with the indictment, but that there was no arrest of the defendant until 6 years after the issuing of the indictment. That makes that case distinguishable from this one because defendant was put on notice of the fact that he was being accused of a criminal offense by the fact of his arrest. So his speedy trial counter not only started when he was arrested, but he was also placed on notice of the fact that there were pending allegations against him. Now, when the defendant was placed on notice, he was not only given information which he signed, although he claims not to remember it, of the court that he was to proceed to, the date that he was to be there, the physical location of the courtroom, the consequences of not appearing, and he signed a document stating that he had received a copy of that order. Now, unless the defendant affirmatively and actively states that the signature on the document is not his, then his signature is affirmative evidence that he was aware not only of the nature of the allegations against him, but of the fact that he was required to appear in court. And at that point, the state does not have a burden anymore to produce in court. The defendant has a responsibility to the court to appear. Moreover, Mr. Byrd has at various times stated that he was detained by officers and given tickets. However, he has not given us any copies of the citations, so we have no way of verifying that the information that he gave to the officers who detained him actually matched the information that the court has or that is contained on the warrant. So, Mr. Byrd has not presented any evidence that despite his detentions, a running of the name that he gave to the officers would have produced evidence of the warrant for his arrest. So, despite the fact that he claims that he was detained at various points, he hasn't actually given the court any proof that those detentions should have led the state to knowledge of his whereabouts and execution of the warrant and production of Mr. Byrd to the court. Now, one of the factors in the speedy trial calculus is the defendant's assertion of his speedy trial right or his failure to assert it. And it is both of those are entitled to strong evidentiary weight in determining whether the defendant is being deprived of the right. In this instance, Mr. Byrd, who was placed on notice in multiple different ways, including but not limited to his arrest, has waited 2 years, 2 months, 3 weeks, and 1 day in order to first assert his right to a speedy trial. Moreover, when a defendant files a dismissal rather than a demand for a speedy trial, that will generally weaken a speedy trial claim because it shows a desire to have no trial instead of a speedy one. Additionally, the impairment of the defendant's ability to present a defense is the most serious of the prejudice factors. However, the law abhors a party who rests on their rights. Not only was Mr. Byrd on notice through various mechanisms of the fact that he had outstanding allegations, but Mr. Byrd has not availed himself through his defense counsel of any remedies for the production of witnesses. Therefore, his blanket assertions that he would not be able to produce his witnesses should not be given considerable weight, especially in light of the relative lack of effort that he has actually put forth in order to produce them. Taking all of these factors into consideration, there is one last factor that I want to really consider, which I believe is relevant to the circumstances, and that is the consequences that would be incentivized if the court granted Mr. Byrd's speedy trial motion. Imagine if defendants simply chose to avail themselves of not appearing in court and then relied on the state to exert its efforts to apprehend them and bring them to court, hoping that if they managed to avoid detection for a long enough time, that the fact of their refusing to abide by the court's authority when they have been placed on notice in multiple ways entitles them to dismissal of their accusations. The results would be patently absurd and they would be against the interests of justice. So for those reasons, the court should deny the defense's motion to dismiss for violation of speedy trial and set this case on the trial docket.
Your Honor, may I respond?
Yes, you may.
Your Honor, the state's first arguments, the first and the last argument about whether or not my client failed to appear for the court, and that it would, the way I interpret it is that the state is arguing that it would basically lead the defendants down a slippery slope of being able to walk away from charges and create a speedy trial issue or create problems that are likely to affect the trial issues. Those arguments, Your Honor, excusing the state's violation of and not doing their job and not providing or not showing evidence of due diligence that they exercised in executing a warrant is not the proper remedy for this court. The proper remedy is to do what they're supposed to do, or what the court did in this particular case, issue a warrant for the failure to appear, require the person to come into court, post an additional bond, keep increasing the bond, hold the person in custody because they are not following the rules and regulations of the court, but it does not provide an excuse for the district attorney's office in not doing their job. Second, Your Honor, I know this is a little bit unusual, but given the state's arguments that there's been no evidence that was provided other than my client's testimony that there were previous traffic violations, I would like to reopen the evidence and be able to show the video, the Coban video that was actually tendered during discovery for when my client was arrested. And that officer does note on this video, in this portion of the video, that there were outstanding warrants for the traffic violations. That will negate the prosecutor's argument that they don't know that my client gave the proper information during the traffic stops that he testified to.
Anything else?
Well, I'd like to be able to show this portion of the video, Your Honor.
State?
Well, Your Honor, I object. Defense counsel would first need a sponsoring witness in order to verify that the video is what it is claimed to be. Second of all, the presentation of evidence is already closed. So I think we're past the point of producing evidence in order to negate or rebut arguments.
And Your Honor, well, first of all, the first response is this evidence was actually tendered by the district attorney's office to defense counsel during discovery. So them challenging the authenticity of the evidence leads questions as to what have they been tendering to defense counsel through e-discovery to begin with. And second of all, I can, if the court does allow me, we can reopen the evidence and my client can testify and the court can see that my client is on the video in the conversation that was had. So I don't think that there's any question as to whether or not this video is what it purports to be. And I believe it's also time-stamped with the arrest date of October 20th, 2019.
Your Honor, may I respond?
No, you don't need to. I'm not going to allow the reopening at this point. All right.
Then I
Your
would just
Honor.
offer up to the court that my client has testified, and he did testify under oath that there were traffic stops that were made and he was not arrested, which was also noted in the judicial notice of the dates that was taken of when this warrant was executed. And I would also like to remind the court that the state still has not been able to present any evidence to the court to be able to show why the state did not execute the warrant in a timely manner. And under Gonzalez versus the state, that is an unjustifiable neglect in their part. And that is how and why the Texas Court of Criminal Appeals ended up ruling that that client, Mr. Gonzalez's right to speedy trial was violated because the state of Texas did not explain the problems that they had with executing the warrant, and they did not make a finding or showing of exercising due diligence and executing the warrant.
And am I correct that the warrant was actually executed on the 21st of October of 19?
I believe the actual arrest, according to the video, is going to be on October 20th, 2019. But I'm sure by the time he got brought in to be booked, it may have been the 21st of 2019.
I know the notes on when you asked me to take notice, not that it's very different, but it was on the 21st is what you recited. But
Yes.
either way, it's on or about October 20th or 21st of 19 is when the warrant was executed, which is just about 2 years after the failure to appear. 22 months, is that correct?
22 months by my calculation, Your Honor.
Be careful. All right. All right, the court finds that the 4 factors have been met, perhaps minimally in some cases, but the delay is inordinate. I do believe that the evidence shows that Mr. Byrd signed the forms that gave him notice to appear in December of 17, which he failed to do. He offers some reason or excuse. I'll take him at his word that he didn't recall the notice, but the notice speaks for itself. Nonetheless, from what you're reciting, Ms. Gonzalez, regarding the Gonzalez case, that it still requires diligence and execution of the warrant by the state, and there's absolutely no explanation or effort to show some form of diligence or effort by the state to execute the warrant. In fact, the warrant was issued as a result of the affidavit of surety to surrender, apparently. And then there was the arraignment on the 12th of December of 17, which he failed to appear. Which was, I presume that on a failure to appear, there was a warrant issued. The record may show which one it was, whether the surety bond issue or the failure to appear. Either way, there's no explanation and no effort to show any form of diligence whatsoever on the form of rather, by the state in bringing him into court. On the other side of it is the fact that the defense did not show or prove any continuity of address, but it does submit evidence that the gentleman was even hired through a state program, which should have brought some bells ringing and some flags waving, if in fact he had the warrant, which apparently he did. Again, normal due diligence would have shown the prejudice at this point is again not very strong, but nonetheless there is evidence of prejudice by way of witnesses, and even the defendant and the witness that he did produce have a limited recall of the situation. And incidentally, that's why the police officers write reports. They don't just come in and testify by recall, they come in and testify from their reports, because the normal human mind is not going to remember details, albeit it was an unusual situation and circumstance. They're still not going to remember specific details. Anyway, I will grant the motion in this particular case because the length of delay, the fact that it appears, if not minimally, but it appears that the witness was available, was not aware of a warrant for almost 22 months later, and there's no indication whatsoever of any effort by the state to find him and inability to find him. They're just, it's a zero. So for that reason, I'll grant the motion. Anything else, Ms. Gonzalez? Would you prepare the order or submit the order?
Your Honor, I believe the motion that I filed, the second one, the lack of due diligence, I believe it was the one that Michelle had posted up, motion to dismiss for lack of due diligence in violation of right to speedy trial. That motion does contain an order for if it's granted or not granted. And then there's also a place for the court to write in, since the motion was granted, that the case is hereby dismissed.
All right, we'll take care of that then.
Thank you, Your Honor. And then may I contact Michelle? Hold on, Frederick. May I contact Michelle afterwards to be able to get a copy of it from the clerk's office?
Of course.
Thank you. And then Frederick, after we terminate this hearing, I will give you a call this afternoon. I have other hearings that I need to get to.
Okay. Can I
right.
say something, please?
You ask your attorney. Ask your attorney if you can do that.
Can I say something, please?
Sure. Go ahead.
I'm very grateful, but this whole conversation, I just been sitting here thinking, like, I'm not gonna lie to you. I don't know what human being on this earth is going to, especially a black young male like me, is going to keep up with their tickets, dates, times. That's second. I mean, that's first. Second, I don't like the way you was talking to me as if I'm a criminal, as if I'm an animal. I'm an animal. I have feelings, and that kind of hurt. I know you're just doing your job and all that, but still, yet, I'm not no criminal, sir. I am not no criminal. I go to work. I work a 9 to 5. Like, I take care of my little brother, my little sister. Like, I don't like being talked to as if I'm an animal, and that's how you make me feel. Like, I feel like a fucking animal, bro. Like, don't do that. Like, that shit hurt. Like, I am a human. I don't have no record, no priors, no nothing. Like, if you did not know I had a warrant out for my arrest, no, if I knew it, took care of it. Why would I be at work with a warrant? That don't make no sense. I felt very, very hurt in this whole conversation. And I didn't even get to say nothing. Y'all was literally talking about me, and I'm just sitting here like, am I that bad? Am I that bad of a person that I have to be talked about like that? Like, honestly, I felt very hurt and very bad. Like,
Mr. Bird, let me say something to you. Our system of justice requires what we call an adversarial one against the other type of presentation of evidence and questioning. I will tell you up front that the questioning that was done with you by Mr. Edelman was completely appropriate and completely proper. I will tell you bluntly, I've been working with this prosecutor for over a year, and he has always shown respect. And what he did with you was properly question you. You're not used to the system, and I respect that, and I understand it. He treated you with respect, never said any kind of thing that would be ugly or inappropriate or offensive. But I understand what you're saying. Please understand that, in my opinion, and Ms. Gonzalez may have the same one or a different one, but in my opinion, Mr. Edelman conducted himself respectfully and properly. I understand that you're not used to that kind of direct questioning, and even making you appear like you don't know what you're doing, or you're saying one thing and the facts are different. That's the way the system works. However, please be aware, the gentleman, Mr. Edelman, acted as a gentleman and acted very properly and asked you questions that were proper. Do not, I can't tell you not to be offended, because you obviously were offended, but please understand that, in my opinion, and I am a person of color, just like you, I would not allow a mistreatment of a witness. Mr. Edelman did not mistreat you.
No, he did not. I'm not saying he did. I'm sorry if you. I'm just saying, me personally, I felt hurt because, once again, I'm not used to this, and the line of questioning, it just made me feel like a criminal. Like, and that's one thing. I'm not my uncle. Them. That's them. I'm not no criminal. I tried to change my life because of them. I'm not like them. I'm different. Like that. I'm just saying. I'm sorry I'm just saying. I just felt some type of way. I respect your job. I know you was doing your job. I'm not saying like you was just being disrespectful or racist. I'm just saying, me personally, I felt some type of way. Not you. I'm sorry.
You know what? Let me say this. I'm glad that you're hurt, because that means you don't want no part of this justice system anymore.
No.
I hope you don't.
I think he froze.
The judge froze.
Ever have any more to do with the courts? You and your family and everybody on the hearing, all of you, all of us, be blessed, be well, and be safe.
Y'all as well.
This hearing.
Thank you, Your Honor. May I be excused?
Yes, ma'am.
And Frederick, I will give you a call this afternoon, okay?
Mr. Bird.
All right, thank you.
Thank you, everybody.
All right.
Kayleen, thank you for your work. And Patty.
May I be excused?
Yes.
Thank you, sir.
All righty.
Thank you, Judge. See you soon.
All right, God willing.
Yes, sir.
Michelle.
Yes, sir.
You take care. We'll Patty, go ahead and stamp the order.
Thank you, Judge.
All right. Take care.